restraints 7 times prior to Floyd's death. State prosecutors argued that on 4 specific times, he went too far and held the restraints, quote, beyond the point when such force was needed under the circumstances. Now, these other incidents were not allowed during the trial. They were not allowed in, I should say, during the trial for George Floyd's death. Still with us, we have Deputy Public Defender for LA County, Philip Dube, joining us. So, when you hear the similarities between what happened to George Floyd, ultimately killing him, and what Chauvin allegedly did to this young man, it's really disturbing and it's stunning. But my question to you is, the jury, will they get to hear about those similarities?
Well, in which trial? Are you talking about if it goes to a federal trial, or are you talking about the other 3 officers who are awaiting trial?
I'm talking about the trial regarding this young 14-year-old boy.
Oh, absolutely. Are you kidding? It's going to come in as what we called prior bad acts, for lack of a better term, to show either intent, MO, pattern and practice, habit, etc. There's an old adage, we say people don't change, they just get older. But they have to be cautious not to treat it as character evidence, because that is strictly prohibited in our courts in criminal cases, unless the defendant opens the door to his character. But yes, I do anticipate this coming in. It's very damaging.
Yeah, and I would anticipate that the jury would get to hear some guidance on legally when it is okay for police officers to use force, and if so, how much. What kind of guidance, if you know details about how much is allowed by law?
Well, depending on where it's being tried in state court, the pattern jury instruction for self-defense is pretty universal throughout the United States. And that is, you're only allowed to use that amount of deadly force when faced with deadly force. In other words, when faced with imminent threat of bodily harm or death. And absent that, you're exercising excessive force, and that's clearly unconstitutional, never mind illegal. In my opinion, I have said this since day one of the Chauvin matter, that they need to amend the United States Constitution to change the standard as to when the state can use deadly force. If somebody is only committing a petty offense, a minor offense, then the force should be limited to what is required to restrain for that type of act. But deadly force is not required in all situations.
Thank you so much, Philip. Of course, much more ahead. Your top legal stories right here on Court TV, your front row seat to justice.